Hello, Miss.
The section
DNA Act of
Every
Hi, Amy. Hello, Miss Susanna. My name is Elmus, and I will be your introductory speaker for the video today. And the video today will be discussing a very interesting topic in which we will discuss the legitimacy and need for laws created years ago in this current day and age. Now, to begin, 2024 has seen the rise of DNA technology and analyzation to an unprecedented level, revolutionizing our ability to gain biological data. While these are great scientific strides, they raise some important questions regarding the continued relevance of legal provisions that predate these scientific breakthroughs. In this video in particular, we'll be focusing on two specific legal provisions, that being Section 112 of the Evidence Act, which is an integral part of family law, and Section 110 of the Islamic Family Law Act. These laws, which were conceived well before DNA technology and analyzation were created and readily made available to the public, had been put in place precisely to address the problems of legitimacy and inheritance. The laws, of course, had been formulated by people using the best of context and technology they had at the moment. However, in view of rapid progress of technology, especially in the DNA department, it has come into question whether the laws we have right now is still sufficient in dealing with the needs and providing justice towards people and families in dealing with their individual situations. I'm joined by my incredibly cool, smart, talented, and hardworking teammates who will share their insights on these provisions and their implications. Jordan will dive deep into Section 112 of the Family Act with special focus on testing out its many presumptions on legitimacy. Edison will speak on the subject of DNA evidence, which will also be supported by different challenges arising regarding the same assumptions under the provisions of the same act. Chloe will speak about the needs for the reform of the Evidence Act in light of the huge advances that have occurred in the field of DNA testing. Chris will take our attention to Section 1110 of the Islamic Family Law Act, under which he will take an in-depth review of legitimacy principles entrenched and affirmed therein. Abner will explain the complications arising from DNA evidence under the Islamic Family Law Act. Finally, Amos will discuss and examine in detail the real and pressing need for updating the Islamic Family Law Act. Such updating is imperative for making the Act reflect the reality and the advance of our new knowledge according to the Act. Sometimes, some legislations, even with the bestest of intentions, loses the meaningful contribution that it once had as society evolves. Today, we will be exploring whether these two laws have met that fate. So, without further ado, let's begin.
Hi, Miss Susanna. I'm Jordan, and I'm now going to discuss the presumption of legitimacy, which was stated in Section 112. The Section 112 is the statutory presumption originating in 19th century jurisprudence when DNA tests had not been invented. For the predecessor of the Section 112, we can trace back to the Section 112 of the Indian Evidence Act 1872, which was enacted at a time where modern scientific advancement and DNA tests were not even in contemplation of the legislature. This section was adopted by Peninsular Malaysia in 1950 and Sabah and Sarawak in 1971. The Section 112 of the Evidence Act 1950 states that any person who was born during a valid marriage or within 280 days of the dissolution, the biological mother remain unmarried and is able to prove that she has no access to the husband, it may be concluded that the man is responsible for the born person. The key phrase here is the conclusive proof, which means that the law automatically assumes that the husband is the father, and this assumption is complicated to overturn. By using literal interpretation, within a valid marriage, whether the wife ever had any sexual intercourse with the third party, it doesn't matter. Without referring to the DNA evidence, the father is still responsible for the born person. Despite there is any other evidence, the court only approved a rebuttable fact that can be omitted is the evidence of non-access. of husband to wife, such as in the case of Ainan bin Mahmud against Sheikh Abu Bakr bin Habib Yusuf and others, which was the 1939 case. Even if they divorce and the wife remained unmarried before the 281 day, within 280 days of the dissolution, it will be the responsibility of the husband to prove that he didn't have any sexual intercourse with the wife during that period. However, the difficulty in the evidence is to prove that he himself didn't have any sexual intercourse with his wife. Moreover, referring to the case of Achak and Nidam, even it can be proved that the wife was committed adultery, the court still considered the fact that whether the husband has sexual intercourse with the wife during a valid marriage or within 280 days of the dissolution. In conclusion, the presumption of legitimacy of Section 112 is about the no access between the husband and the wife. The court will not consider any scientific test or the fact that the wife committed the adultery. And now I'm going to pass to Edison.
Hi, Mrs. Susanna. My name is Edison. It's my turn to introduce you the Evidence Act, DNA evidence, and challenges to the presumption. In modern times, DNA testing is highly accessible and the result can be shown in incredible speed. Modern DNA testing, specifically DNA paternity testing, offers a near-perfect means of determining biological fatherhood. Apparently, the certainty provided by DNA testing can directly challenge the presumption established in Section 112. While we look at Lao Zhanzhen v. Makoto Togashi, 1994, Malaysia High Court held that DNA evidence can be accepted to prove paternity when the parents were not legally married. But the recent federal court case of MPPL and Anwar v. CAS 2024 has reinforced this limited interpretation. The court held that even though DNA evidence might suggest otherwise, the conclusive proof stated in Section 112 prevails unless absolute no access is proven. This case underscores the difficulty of using DNA evidence to challenge the paternity when a child is born within a marriage. From this, we can observe that although modern technology shows its influence in judicial procedures, the absolute considerations of the words no access still remains the gap of Section 112 between current social conditions. Therefore, in an era which has evolved exponentially in the field of science and technology, applying Stone Age provisions prima facie feels unfair. On the top of that, it violates the fundamental rights and the principles of natural justice. It is absurd to hope that a man should be responsible for care of a child against whom he has no obligations, the fact being that he is neither a consenting nor a biological parent of the child in dispute. It is also unreasonable to mandate that a man must prove lack of access within a time span of 280 days. A reasonable human being does not possess the ability to remember what he has been doing or where he was within a time span of those 280 days. Besides, according to Article 5, Clause 1 of the Federal Constitutions of Malaysia, no person shall be deprived of his life or personal liberty in accordance with laws. Leaving the responsibility of someone else's acts onto an innocent man might be a breach of the Malaysian Federal Constitution. Another relevant case, Leo Fokiong v. Pendaftar Besar Bagi Kelahiran dan Kematian Malaysia, highlights how DNA evidence can be used to amend birth records, but only after a court declaration of paternity. These cases illustrate the complex legal landscape and the ongoing struggle to balance the weight of DNA evidence against deeply entrenched legal presumptions. In conclusion, the challenges about Section 112 include the violations of the federal constitution and the strict law which doesn't rationally refer to reliable scientific DNA tests. even in the current precedents from the federal court, still considering the fact that whether the husband has sexual intercourse with the wife within a certain circumstances and period, but ignoring the scientific test, it should be pointed out that the procedure of merely referring to the no asset is a result of no technology assistance to prove the biological relationship nearly 200 years ago. Therefore, certain suggestions to reform should be discussed.
Hi, I'm Chloe. Now, consider a world in which undeniable scientific data, such as DNA tests, is ignored due to the outdated legal requirements. This is the difficulty posed by Section 112 of Malaysia's Evidence Act of 1950, a law in dire need of change. Now, Section 112 presumes that a child born during a marriage is conclusively legitimate unless it can be demonstrated that the spouses had no access to each other at the time of conception. This presumption intended to protect family stability, but it overlooks developments in DNA technology that may definitely prove biological parentage. A notable case highlighting this issue is Cas against MPPL and ANOR 2019. In this case, the High Court first declined to accept DNA evidence, but instead relying on the legal presumption of validity. However, the Court of Appeal reversed the ruling, drawing a critical distinction between legitimacy and paternity. Justice Nalili then stated while Section 112 preserves a child's legal legitimacy, it permits investigations into paternity. This progressive interpretation reflects the need for the law to evolve alongside societal and scientific advancements. But why is this reform necessary? Well, Section 112 was crafted in 1872, when scientific methods for establishing parentage were unavailable. But in today's day and age, DNA tests are more than 99% accurate, but the law still requires proof of non-access rather than admitting genetic evidence. The case of Cas and MPPL demonstrates that this challenging standard frequently results in injustices, such as children being denied the chance to know their biological origins or individuals being incorrectly deemed as parents. Now, legal scholars propose two key amendments. First would be replacing the word conclusive. We could replace the word conclusive with presumptions because this will allow courts to admit DNA evidence while maintaining the presumption of legitimacy. Second, we could broaden the exceptions. Now, instead of requiring proof of non-access, the law should allow for any compelling contrary evidence, such as DNA test results. Now, these changes would align Malaysia's legal framework with the advancements in science, while preserving the social stability Section 112 was designed to uphold. But every child has the right to the truth. Now, under Article 7 of the United Nations Convention on the Right of the Child, every child has the right to know about their biological parents. But Malaysia's current interpretation of Section 112 often conflicts with this principle. Again, in the case of Cas and MPPL, the court emphasized that inquiries into paternity are in the best interest of the child. They provide clarity about their biological origins. In the end, the case highlights that there's an urgent need to modify Section 112. By integrating DNA evidence and widening the scope of exceptions, Malaysia can strike a balance between legal legitimacy and justice. It is time for the law to keep up with science and society. Reforming Section 112 is more than just modernizing our legal system. It is about ensuring the truth and fairness for all. Thank you.
Moving forward, I am going to be discussing about the Islamic Family Law Act and its legitimacy principles. The Islamic Family Law Act of 1984 applies only to the federal territories of Kuala Lumpur and Labuan. It is an act to enact certain provisions of the Islamic family law in respect of marriage, divorce, maintenance, guardianship, and other matters. The Islamic Family Law Act of 1984, specifically Section 110, establishes the paternity, also known as nasab, and legitimacy of a child under Islamic law and addresses paternity through the concept of ascription of paternity. Under the text of section 110, paternity is established only after more than 6 Qamariya, which means lunar in Arabic, months from the date of the marriage, or within 4 Qamariya years after dissolution of the marriage, either by the death of the man or by divorce, given that the woman does not remarry. However, the man also has the rights to disavow or disclaim the child by way of li'an or implication. This section affirms the legitimacy principles, and similarly to section 112 of the Evidence Act, relies on timeframes to establish legitimacy. These timeframes are rooted in Islamic jurisprudence and the concept of nasab, which holds lineage and blood ties and as sacred, integral to Islamic family law. Scholars who specialize in Islamic jurisprudence, also known as fiqh, have stated that the shortest gestation period is 6 months. But while they still differ in their opinions regarding the longest gestation period, Muslim countries generally define 6 months as the shortest period of pregnancy. The 6 lunar months time frame is established as the minimum gestation period based on a combination of medical understanding and Quranic basis, such as verses from the Surah Al-Aqaf and the Surah Luqman, while the maximum period of gestation and time taken to establish paternity is 4 lunar years. Additionally, there has been a history of conflicting opinions regarding the maximum period of gestation, which occurred as the dominant positions were not ruled by medical or pseudo-medical criteria, but rather by the practical consideration to guarantee that the stability of the Islamic social order and its fundamental pillar, the family. Thus, the fixed maximum lengths far exceeded the average 9 months, spanning from 2 to 7, or even in some cases 10 years. With that being said, while grounded in Islamic principles, the specific time frames for determining legitimacy after a divorce can also be similar across Malaysian states. These time frames remain rooted in classical jurisprudence upheld across Sharia courts nationwide to maintain consistency and to preserve lineage. This consistency ensures a unified approach to safeguarding legitimacy, principles, and the rights of children and parents under Sharia principles across Malaysian states. Thank you.
Hi, I'm Abner, and today I'll be discussing the challenges posed by modern DNA evidence to the foundation of Nasab, also known as paternity, established under the Islamic Family Law Act 1984, and particularly Section 110. This discussion is significant as it talks about the balance between traditional Islamic principles and modern scientific advancements. First, let's analyze the time-based structure that is put in place under Section 110. This clause operates under the principle that a child is deemed legitimate if they are born, number 1, after 6 Qamariya months of the marriage being contracted, or number 2, within 4 Qamariya years from divorce or the husband's death, provided that the mother has not remarried. However, imagine this. A child born within the period generally accepted as the appropriate time for childbirth is later discovered through highly advanced DNA testing and other scientific evidence to not be the biological child of the husband in question. This raises a whole host of questions. Number 1, should the presumption of validity be the dominant rule? Or, number 2, should the biological reality of the child prevail? Ayman Shabana, in his in-depth study, points to a very important fact that DNA fingerprinting has stirred a debate concerning the definition of paternity, whether it should be legal or biological. Now, we'll talk about li'an. Li'an involves the husband and wife swearing before a court, with the husband accusing the wife of adultery and disavowing the child. If successful, the child's nasab is severed from the husband completely. Shabana raises a critical point. As DNA testing provides near certain results, its exclusion from li'an creates a gap between traditional practices and the modern realities. Now, let's explore how DNA evidence plays in the overall concept of filiation. Islamic law has long established the issue of paternity primarily in terms of the marital relation framework rather than solely by reason of biological connections. Muhammad Fidel elaborates on this subtle balance by saying that as much as biological paternity is very significant between family relations, the legal system gives more weight to what is in the best interest of the child. This, he claims, means that the law presumes legitimacy, which is mostly based on the legally established marital relations. He further holds that DNA evidence should only be admissible in court under conditions where it corresponds and serves the best interest of the child. Now, let's talk about scholarly perspectives. Scholars that are like Shabana are in favor of introducing DNA evidence, calling it a modern-day innovation, which supplements the conventional means like chiafa or physiognomy traditionally used to determine kinship and resemblance. It is thus contended by these proponents that DNA identification is a far more precise and dependable tool in terms of determination of paternity than the earlier means. Others, like Fidel, are a bit more cautious. They insist that paternity should and must remain linked with marital legitimacy, and that the omission of DNA evidence would undermine the sacredness of lineage and lead to social instability. In conclusion, Section 110 of the Islamic Family Law Act is a vital mechanism for protecting nasab. However, the development of DNA testing calls for a re-examination of the ways in which it's applied and understood. Should we be able to balance on the tightrope between tradition and modernity effectively, then can the Islamic family law remain true to its principles while dealing with the complexity that is the contemporary world? Thank you, and now I will pass this on to my next speaker.
Hi, I'm Amos. Considering the world has entered a more technological and advanced era, the law should also be modernized regarding the Section 112 of the Evidence Act and Section 110 of the Islamic Family Law Act. Since the Act is outdated, there's a growing argument that Islamic Family Law Act should be amended to better reflect the reality of modern science. DNA testing allows paternity disputes to provide a more scientifically method of establishing biological parentage to reduce the potential for injustice. Modernizing the legislation might make it easier to balance modern developments with Islamic beliefs. Considering the rights of the child, in Islamic law, nasab plays a central role in determining the legitimacy of a child's paternity and their rights. Lineage establishes the child's social identity, also dictates important legal and familial issues such as inheritance and rights. According to Islamic law, a child's legal and social standings is determined by their lineage. For instance, a child's right to inherit from both parents relies on their legitimate recognition as their biological child. In Islamic law, maslahah ensures that the child's interest, particularly in religious upbringing, is well safeguarded. A child needs protection as it depends on others for its life. In Islam, the protection of the child begins even before he or she is born. The Islamic Family Law Act could be amended to explicitly include provisions for the use of DNA evidence in cases where the legitimacy of a child born within a marriage or shortly after its dissolution is in question, and clarifying the role of DNA testing in the existing process of acknowledgement, especially when the child is known to have been conceived out of wedlock. This will ensure justice, clarify parentage, and protect the children's rights to inheritance and identity. The need for balance. Modern developments in DNA technology should be carefully balanced with essential Islamic values, such as the importance of nasab and sanctity of marriage. In any reforms to the Islamic Family Law Act, Islamic law must ensure fairness in the determination of paternity, even as it protects the legality of parentage and marriage. Without compromising moral principles or religious beliefs, the appropriate use of DNA evidence may protect justice, ensure children's rights, and improve legal clarity. To conclude, the challenges posed by DNA testing in the context of paternity disputes suggest that there's a need to update the Islamic Family Law Act to reflect the advancement in modern science. The case Public Prosecutor versus Sheikh Muhammad Faisal focused on the presumption of legitimacy under Section 112 of the Evidence Act. Sheikh Muhammad Faisal disputed the paternity of a child from his marriage. The matter was brought before the courts to resolve whether the presumption of legitimacy under Section 112 could be overturned through the DNA testing. The High Court recognized the DNA test as a legitimate proof to challenge the presumption of legitimacy. It marked a significant change in the process for determining paternity and paved the path for the incorporation of modern scientific techniques into the legal determination of parentage in both Islamic and civil family law systems.
Hello again, Miss Susanna, it's me, and I am your closing speaker as well. Now, to summarize what's been said in the video, our group believes that essentially both acts in their current forms may fall short of resolving paternity disputes fairly when DNA evidence contradicts legal presumptions. We believe there is a need to reform these legal provisions. Legal reforms are needed to ensure that these laws can effectively address the paternity issues, especially in this 21st century. Updates should incorporate DNA technology as a valid source of evidence while carefully considering the principles of legitimacy, the sanctity of marriage, and the right of a child to know their biological parents. All in all, we believe that these laws should focus on the child's best interests, where the ultimate goal of any legal reform in this area should be to protect the child's best interests. This includes ensuring that the children have access to the truth about their biological origins and are treated fairly within the legal system. Overall, that is our humble opinion based on evidence, journals, and lots of research that we have done. We sincerely hope you enjoyed the video. Have a wonderful day.